welcome. Good afternoon, and welcome to your weekly legal clinic. This is the law. It's your legal light. It's your health law. I'm Samson Ladia Nyanini, and as we prayed last week, we have been fortunate. I'll be right back to tell you the very good news. So we are continuing with intermeddling, dealing with the property of the dead. What has happened to that regime after the Supreme Court gave a decision striking down a portion of the law? We'll be right back.
Whenever a person dies, whether testate or intestate, we say that his properties devolve onto his personal representatives. So if the person dies testate, his property devolves onto his executors. And if he dies intestate, his property will devolve onto his personal representatives or his administrators. Now, by law, apart from the executors and the personal representatives of the deceased, until the estate is distributed, no other person has the right to use, possess, or deal in the estate of the deceased person until the appointed personal representatives actually do the execution by way of personal. And anyone who does that is guilty of the offense of intermeddling. And that was what was provided for under Order 6603 of CI 47. Now, similar provision is also contained under Section 17 of the PNDC Law 111, which is the interstate succession law. And but the Supreme Court has struck out Order 6603 in the case of ex parte Yvonne Amponsan, but we still have Section 17 of PNDC Law 111 still intact in our law books. It criminalizes any act of any person that seeks to remove, destroy, or otherwise interfere with the property of the deceased person. Now, these words are very broad terminologies that can be interpreted broadly, particularly the generic term otherwise unlawfully interfere. Now, if you are not an executor, you are not an administrator, you are not a beneficiary, you have no right to interfere with the property of the deceased.
You're welcome back. This is the law. It is your legal light. It is your health law. And we're continuing with that discussion, continuing to educate and empower you to be able to do the right thing and assert your rights when the time arises. And our very special guest this afternoon, very privileged to welcome Justice Alexander Pt.2, who is a Justice of the High Court of Ghana and the Gambia. And he has also very recently, I just read something he has written recently. And then just, I think yesterday, I got another article that he has written around this subject. So we are going to have the best of education. Thank you so very much for spending your Easter Sunday afternoon with us.
You're welcome.
Thank you very much. And as you know, last week we had Albert Jemfi, who is with Total Legal Service and lecturer, Wisconsin International University College, Kumasi campus. He also joins us. Thank you, Albert, once again for making the time to join us.
Thank you, and I wish you and the cherished viewers happy Easter.
Great. So we've already received some questions on our social media platforms, and we will deal with them. So I want to assure those of you who have sent questions, including George Nete, those who are asking why we should not be allowed to use our traditional methods. So our customary means that we know of dealing with the property of the dead rather than what we have been trying to teach you here. We'll try and get some answers for you. But we will take advantage of the presence of His Lordship to ask his view and position of what has become of Order 63, Order 66 Rule 3 of the High Court Civil Procedure rules after the Supreme Court gave the decision that it has given, which has led to the discussion that we are speaking about now in the case of ex parte Yvonne and Ponsa Brobe. So, my Lord, what has changed with the law as far as this intermeddling is concerned?
Okay, thank you, Samson. The law before the Supreme Court decision was in two shapes. We had Order 66 Rule 3 and PNDC Law 111, Section 17. Right. And the Supreme Court said, no, the Rules of Course Committee do not have the mandate to come out with a crime. So invariably, they attack, in my view, the criminal segment of the order. Okay. So by attacking it, it means that we still have the civil aspect. If you read the law, it starts with the civil before the criminal part comes in.
That's right.
So we still have the civil aspect where individuals can file application under Order 66 through 3 of CI 47. But if you want to proceed criminally, then my understanding is that you must come under the Interstate Succession Law, PIDC Law 111.
Right. So in your article, your regular articles that you share with the legal community, Friday Legal Corner, when you wrote, I realized that in the order you had written and cancelled only the criminal aspect of it. So by that, what you're saying is that everything else about that order still exists.
Yes. Which
means, what can I do using those provisions still? What can I do?
Yeah, you see, intermeddling was a common law concept where somebody interferes with the property of a deceased person. The law treated that person as what we call executor de santum. That is, once you have undertaken to do that, then the law would expect you to perform all the obligations imposed on an executor. So it means that now if somebody interferes with the estate of a deceased person, the executor or any of the beneficiaries can file application in court for that person to be saddled with the responsibilities of an executor. But unfortunately, if you are not an executor and you pose yourself as an executor, at the end of the day, you do not get the privileges that an ordinary executor enjoys under the law. So it's a matter of just filing application, but at this time, you will not file the application with the intention of getting the person imprisoned, but getting the person saddled with the responsibilities you would expect from an executor. In which case, if any property is being held by the person, you can cause the person to render account.
Okay. So remember that this particular provision of the law that we have been talking about, it says that where any person other than the person named as executor in a will or appointed by a court to administer the estate of a deceased person takes possession of and administers or otherwise deals with the property of a deceased person, he shall be subject to the obligations and liabilities as an executor or administrator, and shall in addition be liable to a fine not exceeding 2,000 or to imprisonment not exceeding 6 months or to both. Now, the education is that the court has struck out the criminal sanction from it, and it is left with the civil portion. But, and I find that both in your first article and in your second article, you deal with that. But there is a but, that still one can be dealt with criminally if you interfere with the property of a deceased person.
Yes.
Right.
That is under section 17 of the Interstate Succession Law.
Right. So if I feel affected, how am I supposed to activate that?
Now, it's a matter of going to the nearest police station to lodge a complaint, as we do in all other criminal cases, for the police to start their investigations, take statements from the accused person and all that. And if they consider that there's a case against the person, it is now the Attorney General or the police or any person with the authority of the Attorney General to prosecute. Now, individuals cannot prosecute intermeddling. That is used to be the case before February.
Okay. I'm trying to remember now if it is in your article I read or it was in Albert's article I read that you raised concern about police not having time to deal with all sorts of things and to deal with matters like this. I don't know if it was yours. Yeah, it was yours. Yeah. So, if I'm going to complain to the police that there's property that has been left for me or for me and my siblings and so on, but somebody is trying to deal with it and that person doesn't have power to deal with it, therefore, they should arrest the person and prosecute the person. Why should the police not ordinarily be interested in pursuing such a matter? And why should we be concerned about the fact that the state will be wasting or making too much expense in that regard?
You see, day in and day out, people die. So, and you go to a community, you look at the number of people who are buried on a Saturday. There are many. Mm-hmm. So if in all these cases, everybody is going to the police station to lodge a complaint, at the end of the day, the police, in terms of number, in terms of facilities, we all know that they are not adequately equipped.
That's right.
So I thought some of these things could have been catered for by the individuals themselves. And the police, even the enthusiasm to prosecute your personal case, this I see is your personal matter. For that's you, right. May not be there. And that's why I thought that the old order should have been maintained.
Right. So, Albert, let me bring you in here briefly, in addition to what you have taken us through last week. My Lord's view from his article is that it would have been good to have left this, untouched, because if a property am to benefit from it, I will take the steps to want to prosecute anybody who is dealing with it. But now, if you have taken it away, then you have reduced the opportunity for us, you have taken away the opportunity for us as beneficiaries or whatever to pursue the people in a criminal manner. What do you think? Should it have been left untouched?
I agree with you perfectly, Samson. I feel the Supreme Court should have left it untouched. Now, the law as it is now, I heard the view of my highly respected judge, and he's someone that I really look up to. And under normal circumstance, we say in law that once he has spoken, I have nothing useful to add. But my Lord, permit me to say some few words. I think, looking at the decision of the Supreme Court in ex parte, even I'm concerned, the Supreme Court was clear that the Rules of Court Committee has no jurisdiction to make rules on substantive law. They can only make rules on procedural law. And as such, in my view, the Supreme Court struck out Order 66-3 in its entirety. Now, under Article 2.1, the Supreme Court has jurisdiction to strike out an enactment to the extent of its inconsistency. And as such, if the Supreme Court wants to strike out part of an enactment, the Supreme Court in its judgment must be clear and express on the enactment or the portion of it that it wants to strike out. In my view, that was not stated in that particular case. And again, even if you look at the reasons for that the Supreme Court gave, the Supreme Court said that the Rules of Court Committee cannot make substantive law. And if you look at the laws, Order 66-3, the entire law, both in its civil and in its criminal aspect, are substantive laws. So if the Supreme Court cannot make criminal law, then obviously they cannot make substantive law bordering on interstices. But I feel that looking at what my Lord stated, people to go through, not just reporting to the police, but even if the police decides to take up the case, you're also supposed to go through the processes of putting the person before trial, taking his plea, filing of witness statement, witnesses to come. That is too much of a cumbersome process, if you ask me. And by the time that is done, because the court can probably make interim orders, or if you look at Order 17 as it is when the court has found the person guilty of intermeddling that the court can make further orders for the restoration or something of the sort. So if it takes about 2 years, 3 years for someone to be prosecuted for intermeddling, by that time the estate could have gone to waste. And I feel that looking at the fact that in the past it was a quasi-criminal offense, which can be determined on the basis of an application, a person could just file, and in about 2-3 sittings, the court gives a ruling, and the estate is preserved. Because the whole point of filing probate of these laws of intermeddling is to protect the estate so that the estate does not go into waste or go into the wrong hands. But now that the Supreme Court is saying that you are supposed to go through Section 17, which even in my view only applies before distribution. So under Section 17, a person cannot be prosecuted for intermeddling after the estate has been distributed. Although we know as legal practitioners that intermeddling can still occur after distribution. So I feel the Supreme Court should have left it as that, and probably allow some statutory interventions to come rather than to strike out the provision as unconstitutional.
All right. And so that's an interesting, perspective that he brings on, that your interpretation of the decision is that it is only the criminal aspect that has been expunged, cancelled.
Yeah.
He says, from his reading of the judgment, it has been cancelled entirely. And even though this legal clinic is for the generality of the public, particularly those who, need this to appreciate some bit of the law, I'll let you know that there are lawyers, there are law teachers who are watching us. In fact, there are judges who are watching and listening to us. And there's a law teacher who said he was going to begin teaching this subject, this topic to the students. And so he's very interested in listening to know what the status quo now is. So what do you say?
That's my view.
Right.
And that's what makes the law interesting. And one thing I would want to add to what he said is that now the Supreme Court is saying we should go to Section 17. And Section 17 is very complex. It looks simple, but there are certain, I know, trial judges are going to find it very difficult going about this due to some words that were used. For example, like my brother said, the whole provision talks about property before distribution. It also talks about entitled person. Unfortunately, the lawmaker did not interpret who an entitled person is. So are we talking about anyone entitled under the Act, which goes beyond the nuclear family? Or are we talking about only members of the matrimonial family? If you also read Section 17, you come across the property. Is it a property? You start with 17A, talking about the matrimonial property. And you go to 17B1, which talks about the property. Are we alluding to the A, that's the matrimonial property, or we are talking about different, another property other than the matrimonial property? And if you go further, you go to the III, you see the property of the deceased. So, and that is where, in my view, the Supreme Court put or placed the intermediate around, because they highlighted on the 17 III. But even with that, I thought the III should have stood alone. It should not have been brought under the B, which talks about the nuclear family, the spouse and the children. So the Act or the session is going to create problem for trial judges. And I would recommend, or I would want the Judicial Training Institute, as early as possible, organized a training for all judges, especially trial judges, to be able to appreciate this session. Otherwise, there's going to be confusion.
Okay. But I thought that when you talked about an entitled person, it was not going to be a difficulty because we know, according to PNC Law 111, which we are talking about, Section 17, the entitled persons are known. It says surviving spouse and children, surviving spouse, surviving children, surviving parents, and surviving customary successor. So these are the entitled persons. Is that not correct?
No, under the session, if you read the session, the heading itself is offenses against spouse and entitled persons. But if you go to the memorandum says nothing about the extended, nothing beyond the nuclear family.
Right.
It only concentrates on the nuclear family, the spouse and the child. And if you situate it you look at the A and B, you see A is talking about the matrimonial property.
Right.
You go to B1, it talks about unlawfully depriving the entitled person of the property. Which property? The emphasis is on the. A1 has 17(1)A has talked about the matrimonial property. So which property are we talking about? In my view, it's the matrimonial property that the B1 is also talking about.
Right. Abedjemfi, before we proceed further, and so that we don't stay around where we know that only limited persons are going to benefit. If we stay here, we are going to only benefit lawyers and law teachers and law students, but we want the biggest beneficiaries to be those who do not know the law and who are in some of these situations and need some solution. Now, I want us to proceed to the next question from where we stopped last week. But before that, can we go over again on the question of what a person cannot do on the death of another without a will? What you cannot do about their property and what the consequences are. By way of some recap again, can you take us there?
So we are saying that under the law of intermeddling, a person cannot, unless he is an executor or administrator, cannot use, possess, administer, or otherwise deal with the estate of a deceased person. And we explained estates last week to mean the properties, self-acquired properties of a deceased person which he leaves behind after his death. You cannot deal, use, possess, or in any way distribute his estate.
Okay, Albert's slide just got frozen. He has a very clean line today and also last week, but I don't know why it's getting frozen now. So maybe I come to my Lord here. Now, my Lord, the question is, somebody is asking the question, there are about two people who are asking the same question, that they know their customs and their traditions. And when somebody dies, what should happen to the property of the person who has died? Why are we saying they must follow something else rather than what they know in their custom, traditions, and even in their religion?
Thank you. We all know what was happening before 1985. For the matrilineal system of inheritance, if a man passed, you see the family members going to lock the rooms, depriving the spouse. If you heard, this is my uncle's television, you cannot watch it. Mm-hmm. There were a lot of abuses, and that was why the lawmaker came out with this law. So this law is seeking to protect basically the nuclear family, being the surviving spouse and the children. So the lawmaker realized that something was not going on well. Something was not right. So this law is to deal with a particular mischief in the society. So we've graduated from that. If the traditional system was unquestionable, there wouldn't have been this law. So
Right.
because of the abuses and the abuses and the issues that were associated with our customary system, that was why the law 111 was enacted.
Albert, I hope we got you back on a clean, streaming now. Is it to say then that my tradition, my custom, my religious position on how to deal with the property of the dead person does not apply anymore? And why is that so?
Right, so I'll say that Ghana is a country that is governed by the rule of law. Okay, so if you look at the laws of Ghana is amply stated under Article 11 of the Constitution. And the laws of Ghana, although recognizes customary law as part of the laws of Ghana, a custom that is contrary to law, in other words, an act of parliament, a CI and LI, the Constitution, is void. And there are various study cases to that effect. And as such, if there's a customary practice that sins against PNDC Law 111, which is considered to be an existing law and has the same status as an act of parliament, that custom is void. It cannot be recognized as part of the customary laws of Ghana. Again, Ghana is not ruled by any spiritual book or scripture. And as such, if there is any scripture that goes against the laws of Ghana, to the extent of law, and I'm putting my words carefully, to the extent of law, that scripture is inapplicable in Ghana. And as such, it is only the PNDC Law 111, the Wills Act, the Administration of Estates Act, and other such laws that governs the distribution of any other property, the properties of a deceased person, and cultural or religious practices do not come in here.
Right. My Lord, last week someone asked the question how they can lawfully deal with the property of the deceased. And the answer to the person was that they needed to go to the court and get an LA. When we're done with the show, the person gets back and asks the question, but there's money involved. They don't have money. How are they supposed to get these letters for administration to be able to deal with the property so they don't get into trouble when they don't have money?
It's if the person does not have money, I will entreat the person to go to legal aid, because that's what the law says, that you need letters of administration and probate to be able to deal with the property or administer the property. So if you don't have it, then there's an agency agency of the state that is able to help those who do not have the means. So the person can try his luck with legal aid. Right.
So we brought legal aid here, and you hear them. Some of the cases they do, a good number of them include things like this. So pay attention to that. Now, tied to that, someone's concern was that there's money, the deceased has a bank account, and there's money sitting in there. So can they have access to that money to use, to do some of these things?
So who should the bank give the money to? Is it A or B or C? The bank will not be able to know who is the eligible. The mere fact that, yes, you have lost a relative does not mean anybody can go to the bank to say, I want money. The law deals with the proper person, and that's the administrator, the one being given authority by the court to deal with the estate. So that person should be able to get the necessary documentation, that's the letters of administration, and go to court. It's simple. Otherwise, every family member will say, oh, I'm the son. Let's say the man had 10 children. The mother will go today, the father will go tomorrow, the uncle will go the next day, and there will be confusion. That's why the law says, let's deal with only the administrators. So the bank, no diligent bank, will deal with members of the family without letters of administration.
Now, you are the lawyer. Must it always take a lawyer? Because I have had an engagement with some of those who called, and the issue is, I can't afford a lawyer. What if I can't get legal aid services? Is there a way I can still go to the court without a lawyer or anything and get this done for me? Yes,
All right,
Albert.
so you can actually get it done without a lawyer. I think most court registrars, particularly those in the district courts, have been trained to assist people in the preparation of letters of administration and also to in application for probate. But to add to what His Lordship said, even if you get legal aid, even if you get free services from the registrar, you are still required to pay the estate duty. That one is not negotiable. You are supposed to find money wherever you can to pay the estate duty before you can be issued with the probate or the letters of administration to administer the estate. So even though the legal aid will assist you, you still need to get some money to at least pay off the estate duty before you can administer the estate. So it still involves money. I as a practitioner, will not rule out the fact that you need money to be an executor or an arbitrator.
Right. And so, Judge Nete, your question, I suppose, has also been answered. Your questioning was, you say property of the dead definitely includes bank accounts. What does the law say about bank accounts of the dead? Does the law provide for the bank account of the dead to be treated any different from the way a dormant account is treated? Does the next of kin automatically become the owner of the balance of the bank immediately the original owner dies? That's what you wanted to know. And I'm sure that you have received sufficient education in that regard. And this is the law. It's your legal light. It's your health law. And we are privileged to have Justice Alexander Osei Tutu, who is a Justice of the High Court of Ghana and the Gambia, join us to give us this education. And of course, you also have Albert Jemfi, who began this with us last week. He's with Total Legal Service. He's a lecturer, Wisconsin International University College, the Kumasi campus. We will open the phone lines now, and you have the opportunity to call us and to now fire your questions, so to speak, directly. If you call, please go straight to the question. Just go straight to the question. That's all I'll say. Go straight to the question. Thank you very much. Now, I want to go over the law that is being referred to now, that you can go to the police to make a complaint, even though we referred to it last week. Let me read it again for you. That's the Interstate Succession Act 1985, PNDC Law 111. And that law says that a person who, before the distribution of the estate, last week it was explained to you, estate means property that the dead person has left behind. A person who, before the distribution of the estate of a deceased person, whether testate or intestate. Testate means you died making a will. Intestate means the person died without making a will. If the person died making a will, then it is the will that will be used, but there must be a probate or letters for administration with will annexed. Now, it says, if you unlawfully eject a surviving spouse or child from the matrimonial home, contrary to Section 16A, if you unlawfully deprive the entitled person of the use of a part of the property of the entitled person, a property shared by the entitled person with the deceased to which this act applies, or you remove, you destroy, or otherwise you unlawfully interfere with the property of the deceased person, then you commit an offense and you are liable on conviction to a minimum fine of 2.5 penalty units and not exceeding 250 penalty units, or to a term of imprisonment not exceeding 1 year. And the court or tribunal shall make any other orders that it considers necessary for the reinstatement or reimbursement to the person thus ejected or deprived. And as I keep saying, a penalty unit is 12 Ghana cedis. So you multiply that 250 penalty units, and you get the amount of money you may be paying. So actually, the CI 47 or the 66 Rule 3 regime was actually better than this one. It's actually better than this one, even the non-criminal provision. Correct?
Yes.
Right. Because you were not only expected to make the fine payment or go to jail for that one and for 6 months. Or both. But you were also to pay in accordance with the value of the property. That appeared a lot better. That's why they are saying maybe it would have been better to have left that as it was. It says that you were either on conviction to pay a fine not exceeding 500 penalty units or twice the value of the estate. Twice the value of the estate. That was such a big punishment that anybody could suffer. All right, so today we are opening the phone lines a lot early. Richard, you are calling us from Insawam. You have the best. Ask your question straight and you get the answers.
Hello.
Yes, Richard, go ahead.
Me pacho mekechi.
Richard, yetiu.
Pacho. Me fan opi me fan say me wo property but me name property na me wo no me de me bedding na ato so. Ina me ni ho biem. Enti say me tia se de me anka se me de ma me ba no but me register de no wo me bedding mu na me ni ho biem. Enti say me ni wa sa property ni ti me ye me ba no e de ana.
Okay, Richard, that's it. Right, my lord, what will you say?
Property registered in the name of
the child. So when he dies, he's asking if it to be part of his estate or it to be for the child.
Whilst alive, if he created the impression that the property was for the child, then it means that there are two types of gifts. One we call gift inter vivos, which we give during the lifetime of the person. And one I can say, if I die, we add a condition to it. So whilst alive, if he created the impression that the property was for the child, then even at the time of his death, the property is not considered part of his estate. But if he made it conditional that after my death, then after his death, it will be treated more or less, if he made a document to that effect, it will be deemed as a will and it will go to the child.
Okay.
So it will depend on the intention, whether during his lifetime he gave what we call gift inter vivos. Then at the time of his death, it is not considered his property.
All right.
For anybody to even talk about it.
All right, Shaibu, hold on for me briefly. I'm bringing Abel Jemfi on. Last week, his chi was impeccable in explaining to those who wanted to hear us in chi. Albert, what do you tell Richard?
Okay. In chi, right?
Yes, please.
Okay. Me my dream no. Say auto a japati now the body into swa. Remuno, your funny say, and a presumption. Yes, to say, what your wife say, person with the child. And he say, Obi for 4 say, a Japadian, what in the to so keke. Now, why that wife can say with the channel? On the Remuna should done to say, but then what dance say, but say, oh, but in the body to so keke. No, my reasons in tear, what do body to so keke. Now, what I say, Sabia, a Japadian, a crano, Edia, Nemo make up upon the Japadian. Nemo more would say, but in the body so a din to so keke. When to me and fat dance here, a bet say, or did to so keke, dear, Mramu to say the judge kind of fun to say, what your wife and say what they chow ban. That's all the Japadians watch. Last week in the car, say what the chat and come with Japadian who be. It is answer my Kenyan and Mamubi. I think that's the best.
Thank you. Yeah, that's it. Shaibu, let's hear you.
Okay, sir. Good afternoon to you. Yes.
Good afternoon. Please speak up.
Yes. My question is, in case I had a will and it's only me who knows where it is, and I didn't make any revelation to my successors. And unfortunately, I passed on. No one can find my will. So this one, how will my successors do?
Okay. Shabu, you are saying that you made a will.
Yes.
But it is known to only yourself.
Yes, sir.
So when you are dead, how can anybody access it? Correct?
Yes, sir. Yes, sir.
All right. Thank you.
Yes.
Yes, my lord.
Yeah, if the family members have cause to believe that you made a will, they may conduct a search in the court. But if they do not suspect and nobody comes out with a document, then the property will be deemed. If nobody is aware, how can we share?
Right.
So in that case, your property will be distributed in accordance with Law 111. You take it that it's when we chance on a will that we use the provisions, we go by the content of the will. But if we do not come across any will, we take it that you didn't make any will, and we go by Law 111.
Right. And Shabu, when you make a will, there's a way it works. So it's probable that somebody will know and they will get to know that you had a will. So they will rather go for your will where you yourself have stated how you want your property to be distributed. Albert, can you briefly tell us, when we make a will, who is likely to know that we have a will?
All right, so when a will is made, by law, you are supposed to have 2 witnesses to sign the will. So if the 2 witnesses are alive, they will know. If you make the will with a lawyer, the lawyer will deposit a copy of the will at the High Court closest to the last place of abode of the deceased. So whenever a person dies and you want to know whether the person made a will or not, look for the places of abode of the person. And like my lord said, conduct a search at the High Court closest to that place of abode. If he made a will, a copy of the will be there. But if throughout all this, the person did not deposit a copy of the will at the High Court, and after the property has been distributed in accordance with PNDC Law 111, and later the will is discovered, subject to certain processes that you are supposed to go through, the properties can still be redistributed under the will. So wills do not expire. And whenever it is found, the property can be distributed in accordance with the will.
Right. And remember last week, Albert gave the education about executors. Apart from the witnesses, when you are making a will, you would get a friend or 2 who become the executors, so that in your absence, they are the ones who will lead the people who are supposed to benefit, who will tell them that, oh, there's actually a will, and this is what it is. So they will lead to court and get the process that will allow you to benefit from the will. Prince, you're calling us from Akosombo. Let's hear you, Prince.
Lawyer, good afternoon.
Afternoon.
I'm happy to see you today. My interest is for you to get justice for Latif for it. Please.
Sorry, we are talking about intermeddling, property of the dead. How should it be dealt with? Latif has a matter in the court. It is being prosecuted. Thank you.
Thank you, but the case has been delayed, please.
Okay, Prince, we'll go to Solomon. Hello, Solomon.
Yes, please.
Yes, Solomon, let's hear you.
Please, this very issue that you are dealing with, and when it goes to the court, can it be referred to the court-connected ADR?
Is that what you're questioning?
Yes, that's my question, because we're talking about legal, is it legal what? I've forgotten about that establishment.
Okay.
There's legal something I've forgotten.
Okay.
Apart from that, can it also go to ADR?
All right, thank you.
Thank you. Good.
Lord, when does ADR coming in such matters?
Yes, if you go to the Courts Act, I think section 73, yes, it's a crime, but the law promotes reconciliation unless it's a felony or aggravated assault. So I believe that this one can be referred to ADR, especially when it involves members of the same family. It's one of the instances that the law is not interested in punishing people. The law is interested in ensuring that at the end of the day, there's peace and reconciliation. So it's possible for such a matter to be referred to ADR for the family members to sort themselves out.
Okay. So if somebody has wrongly interfered with the property of the deceased, instead of taking the process to have the person, jailed or make them pay fines as under the law, my Lord is saying that it is possible, even when you appear before the court, sometimes they themselves, the judges, will be the first to tell you that, look, this is a family, you don't need to be fighting. Go, we can help you to settle this matter nicely without anybody having to go to jail or something like that. Who do I have next? Thomas. Thomas, you're calling us from Kumasi. Let's hear you.
Pacho, good afternoon.
Good afternoon, Thomas.
Me Pacho, Ebia Busiano, Papa no Ewuye, one year property, but what you are saying, nothing can say Muntino, none mammy, or your property be my mammy, and I'm mammy free. And Papa no year and free, or assassin now, Owuye. As the family members no aje efie no any assassin nyina say papa ne ye japade ne ma nti no ayo omo de me wa so ma me no aye ma no wo.
Okay.
Nti me no sisi ade kwa kwesi nti pa cho mo chichi mo
Jinaso ma wa men kwansa Jinaso Albert.
Yes, something.
You heard it? Yeah.
Yeah, I had a question. Is if I understand him, the man developed the property for the mother. The mother passed on, and he passed on subsequent to the mother, and the family is now claiming that the property belongs to the mother and not to him. If that's a question.
Yeah. So how do they deal with such a property?
All right. So if you make a gift of a property to somebody, that particular gift does no longer form part of estate. I mean, catch you not just say, oh, mammy, we are Japadia mammy, your mammy dear. So, oh, mammy, who are now mammy and your walla, a Japadia never channel under PNDC law 111. Say a chair under PNDC law 111. That's how now your mammy bakura. Say Japadia never says about your wood dear under PNDC law 111. It's a bear wood dear. Your open and absent the Japadian aye. Say we ye ma which have the chow mammy, but now some mammy we in the baba ye what dear. The mom so mammy woo and mabby baby ya. That's a woo. When you know the Japadian ye would dear, and send the one castan of the chain would ye. And the son of a busa for no busa for mumu edia. The mum ye better a Japadiano and a PNDC law 111 to say the mammy we ya 1 year and I wait in the Japadia.
Right. So I realize he may not have followed when my Lord explained to our other caller, but Ebusiano, there's obviously the portion that the family gets to benefit if it's being distributed under PNDC law 111. Give him an idea what it is.
Okay, and see, a Japadia nipa na obu no owo nyina no. Ye di kan eboabo ni nyina no. Na ye yi fie baako asinchen. Efie baako no eye egire ene ne mmadea. Ansa na a Japadia nipa ko wo ketinketi a owo nyina ne cars a wo a e kan enya adwuma nyina e ko ne yire ene ne mmaho. Enti cars, fridge, TV, fan, kuku bibia e ko ne yire ene ne mmaho. Eji eno no asinchen a de aka no ne asaso ache. De aka no ye chemu 16 de chemu a a man who is also 9. Ye back na, see back in the sinchen, no money in the sinchen. No, the acano, a year a man who 9 out of 16. A year and 3 out of 16. Now the acano, as also at Chabubi, send him mammy papa tiasia, and mammy papa bena a fan. Anna, the acano to work for the Bussian house, send him mammy papa tiasia, or Moody never saw for a Bussian hole, a beam, Tisana. A chair at Japadiano. It is a mammy will feel back okay. And not woo ya. The Japadio wouldn't ever call the Nukunu and the Maho, Busiani bien no opinion.
Thank you very much. I think I can take one last call if there's a caller on. If there is not, then I will just revert to the studio and seek to wrap up. If you are just joining us, this is the law. It is your legal light. It is your health law and privilege to be hosting Justice Alexander Pt.2, Justice of the High Court, Ghana and the Gambia, who has graciously joined us to help us explain these matters to you. Remember the last time he was here, we introduced to you his book, Essential Themes in Land and Customary Law. And this have to do with property. And the matters we are discussing too, as you can see, have to do with property. Isaac, you'll be our very last caller. You're also calling from Kumasi.
Okay. Mr. Ladi, thank you for the opportunity. I want to find out if I've made a will. Is it possible, apart from the court, is there any other place, like can I keep it in the bank or a different place where it will be very possible for my people to trace it in my absence? And my second question is that I have a property and I have will in the name of my girlfriend. He's not married, legally married. Then I pass away. What becomes of her fate in the sharing of the property?
Okay. Is that the only property that you have willed to your girlfriend, or you have children and you have made sure that the children have been catered for before you gave something to your girlfriend?
No, I don't have a child at that time.
Okay. All right. Thank you for your question, my lord. Yes.
Thank you. We call it will. So you decide who should benefit. But under the law, if you make a will and you exempt certain people, like your spouse and your children and your parents, the law allows them within 3 years to go to court for a reasonable portion of the estate. So if you don't have, let's say, a spouse, a child, none of these people is alive to challenge it or to go to court for a portion, then it will go to the person, right, the girlfriend. But if any of these persons is alive, then the person can go to court for a reasonable portion of your estate.
Right. Albert, the first part of his question was, could he take his will to some other place other than depositing it in the court?
So you're entitled to take your will to any place that you want. But in determining whether your executor should be granted probate or not, the court will look at only the will that has been deposited in the court. So if the will was never deposited, but the person dies, a copy has to be deposited in the court. So the court will look at the copy of the will that has, and it's not going to look at any other will. So if you want to put it in a bank, put it under your pillow, under your bed, you're entitled to do so. But when you die, one copy has to be deposited in the court. If there's already a copy in the court, then the will deposited at the other places will not matter.
Right. So once a lawyer assists you to do your will, they would always tell you the one place that you must deposit one of the will is in the court. There's a place where the wills are kept. And then in your absence, those who must benefit will be led and it will be removed. It's sealed. And then the seal will be broken. It will be read after the court has given permission for it to be taken up. And then those who are to benefit will get to know what portion exactly they are getting. Let's get your very final words by way of advice to people who continue to intermeddle with property despite the advice that comes to them in through places like ours. Albert, start with you.
All right. I think my lord will take care of the advice. Let me just make one comment, and that still has to do with the Supreme Court judgment, particularly on issues of jurisdiction. Now that Order 66/3 has been struck out, the only law left is Section 617 of PNDC Law 111. That section looks to give jurisdiction to intermeddling only to the district court, because if you look at the punishment regime, either a fine or a maximum of 1 year imprisonment fixes jurisdiction on only the district court to handle issues of intermeddling. I would humbly pray that as a matter of urgency, our lawmakers will come up quickly to make laws that would particularly enhance the punishment regime. So maybe 1 year to some maximum number of years, so that we could get high court and circuit court judges sit on matters involving intermeddling, particularly where the property intermeddled or the estate is a very large one. Other than that, this the 1 year punishment is not deterrent enough to prevent people from intermeddling in the estates of a deceased person. That is the only thing I would like to say.
Thank you, my lord.
Thank you, Mr. Jemfi, but I beg to differ. The High Court and the Circuit have jurisdiction in all criminal matters. So the mere fact that if somebody steals this pen, you can still go take the person to the High Court. So the mere fact that the value or the amount is small does not mean that it's only the District Court that has jurisdiction. The High Court and the Circuit Court can still deal with the matter. I would want to emphasize that Section 17 goes beyond the estate of the deceased person. Because if you look at 17A, it says that anyone who unlawfully ejects a surviving spouse or child from their matrimonial home, contrary to Section 16A. And if you go to Section 16A, it says that, especially B, you cannot eject the spouse or child where the matrimonial home is rented property, unless the ejection is pursuant to a court action. So even if the house is not property of the deceased, you are landlord, you can't eject. It's not the deceased person's property. You can't eject the wife and child. Okay. You can only eject the wife and child when you have gone to court and have been given an order to do that. And you go to C, it says where the matrimonial home is the family house of the deceased, unless a period of 6 months has elapsed. So even if the person was staying in a family house, not his own property, though Law 111 is dealing with the estate of the deceased person, this one is not his property, but the law says you cannot eject him until after 6 months. So this is the angle I would want to bring to the attention of hearers.
Good education. Thank you all so very much. This has been The Law. It is your legal light. It is your health law. And my guests have been His Lordship, Justice Alexander Pt.2, Justice of the High Court, Ghana and the Gambia, and Albert Jemfi, Total Legal Service, Lecturer, Wisconsin International University College. I'm Samson Ladia Nyanini. Thank you all so very much. Enjoy your Easter. Tomorrow is a holiday. At 11 a.m., you can still watch a repeat of this broadcast. Thank you. Have a good afternoon.